Hi, my name is Volker Krüger. I'm an attorney and a conveyancer here at Velden-Duffey Attorneys in Rustenburg. I have a list of frequently asked questions in front of me regarding the transfer and the bond registration process, and I'm going to give you the answers which I believe are appropriate for these questions. First question: how long does the transfer of a fixed property take? Anything between 4 weeks and 4 months, or sometimes unfortunately longer even, is the estimate that we would normally give. This depends on various circumstances beyond our control, such as the cooperation that we get from the banks, the municipalities, SARS, the receiver of revenues, in other words, transfer or bond registration attorneys where there are linked transactions. Then also in respect of developments and deceased estates, there are additional requirements that have to be met, which also might delay the transfer registration process. But we will certainly do everything in our power to make sure that your transaction is registered as quickly as possible. Next one: how much are the transfer and the bond registration costs? You can actually have a look at our website. There is, under Tools, an option available, Bond Cost Calculator, where you can look at your specific bond loan amount and capture that, or the purchase price, and then you can establish the transfer registration costs or the bond registration costs. We will, however, in any event, also send you an account with details of the amount that you will have to pay. Next one: what is the difference between transfer costs and transfer duty? Transfer costs actually include transfer duty, and then also include the conveyancer's fees, in other words our fees to attend to the registration process, and then also the expenses that we have to incur, such as the deeds office fees that are payable. We will once again send you a statement of account to set out all the amounts applicable to your specific transaction. Transfer duty, by the way, is the tax that is payable to SARS upon the sale and the transfer of a property. Remember that there might also be an exemption amount applicable to your specific transaction. If your purchase price is below the current exemption amount, then you would actually have or not have to pay any transfer duty at all. We will certainly let you know whether that applies in your transaction or not. Next one: when are the transfer and the bond registration costs payable? We will certainly inform you when you have to make payment of that amount. Please keep in mind that you cannot pay the registration costs after the transaction has been registered at the deeds office. You therefore have to pay us the full amount due before we can lodge and register at the deeds office. Can I get a discount on the bond registration costs? Unfortunately, only if the bank's conditions do cater for such a discount. If not, then you'll have to pay the full amount. What happens if the bank does not timelessly approve the purchaser's loan application? The contract of sale between the parties would normally stipulate by what date the purchaser has to obtain the loan. If he fails to do so by that date, then the contract actually lapses from a legal point of view. If the parties are, however, still happy to proceed with the transaction, then they can simply sign a new agreement, and that transaction can then still be registered in terms of the new agreement signed. Can the bank withdraw my loan? Yes. If, for example, you incurred further debt after the loan had been granted, or if, for example, something happened to your credit record. For example, if someone obtained a judgment against you or listed you as a bad payer, then the bank might decide to unfortunately withdraw the loan that they had previously granted. Can I make a further loan to pay the transfer or bond costs, or to pay the deposit required by the bank which granted me a loan for the purchase price? Normally not. Typically the bank will actually require you to pay the costs or the deposit from your own funds. My agreement of sale stipulates that I must deliver bank guarantees for the purchase price. How do I do that? You actually don't have to worry about that. The bond registration attorneys that will be instructed by your bank that granted you the loan will attend to the issuing of those bank guarantees and will deliver them to the transferring attorneys. How long does it take to get permission from the bank to proceed with the registration of my mortgage bond? Anything between 2 and 7 business days. That actually depends on the specific bank. Do I have to take out life insurance cover for my mortgage loan? Only if the bank requires you to do so. Many people, however, take out life insurance in any event to make sure that their family does have sufficient funds available to settle the outstanding bond should you pass away before it has indeed been paid in full. When will the bank deduct the first mortgage bond installment from the purchaser's bank account? The banks don't all follow the same policy. I would therefore suggest that you find out from your specific bank what their policy is. How much money will I as seller receive? The starting point is, of course, the purchase price, and then from that purchase price the cancellation figures would be deducted. In other words, the outstanding balance of your existing mortgage loan. In this regard, you should keep in mind that the interest keep on running on that balance until the registration date. Also keep in mind that you should actually notify your bank as soon as possible of the sale of the property so that they will not charge you any penalty interest for settling the outstanding balance before the full term, normally 20 years, of the loan has lapsed. Then cancellation costs are also deducted. Agent's commission, if applicable, is deducted, and then also the costs of the obtaining an electrical certificate of compliance, so-called COC, if you haven't already paid the cost thereof to the electrician yourself. Why do I have to pay cancellation costs for the cancellation of my existing mortgage bond? When we register a bond at the deeds office, that bond has to be noted against the title deed, in other words the property, at the deeds office. Now likewise, if that bond is cancelled later, the cancellation also needs to be noted against the title deed and the property. So our costs as conveyancers are then for the cancellation process that we have to register at the deeds office. What if there is a shortfall on the seller's finances? In other words, there's not enough money available to cover the outstanding balance on the existing loan of the seller. You can actually ask the bank to reduce the cancellation amount, which they are quite often prepared to do. They would then require you to sign an acknowledgement of debt to cover the outstanding balance after the reduced cancellation costs have been deducted and the proceeds of the sale have been used to partially settle the balance of your loan. Will I have to pay VAT on the sale of my property? In most cases there would actually be transfer duty relevant and not VAT. If the seller is however registered for VAT and the property is part of his VAT enterprise, then it would be a VAT transaction and no transfer duty would be relevant. For example, if there's a farmer that sells his farm as part of his VAT enterprise, or for example, if there's a landowner who owns a commercial property which he's rented out and he's registered for VAT, and that once again property is part of his VAT enterprise, then that would, for example, also be a VAT transaction. Will the transferring attorneys invest the money that I pay into the trust account so that I earn interest? Answer is yes. However, they need your FICA documents, so make sure that you send them the FICA documents as soon as possible. Can I buy and sell a property at the same time? Can I use the proceeds of my sale of one property to buy another one? Answer is yes, you can do that. The two transactions can then be linked so that the proceeds of the one transaction can be used to pay the purchase price of the other transaction. The attorneys then will link the two transactions and actually also lodge and register the two transactions at the deeds office simultaneously. Who must obtain the electrical certificate of compliance? The contract of sale will typically stipulate that the seller has to provide such a certificate. If the contract is, however, silent in this regard, and if the bank requires an electrical certificate from the purchaser, then in our opinion the purchaser will actually have to provide such a certificate. Must the electrical certificate of compliance, or the COC, also cover the electrical fence if there is one? Answer is yes. How old may the electrical certificate of compliance be? The certificate may not be older than 2 years on the date of the registration of the transfer. I do not have funds available to pay the municipal clearance figures. What can I do? We can actually arrange bridging finance for you, in other words, a loan. This we can do once everything is ready for lodgement. In other words, all the documents must be signed, the purchase price must have been secured, all costs must have been paid, and all the other requirements of the transaction has to be, or have actually been met. After the registration of the transaction, we will then use the proceeds to pay the loan back to the bridging finance facility. So yeah, you are welcome to contact us, and if the purchase price is sufficient to ensure that there is enough money to cover the loan as well as the interest payable, then we can indeed help you with bridging financing. Also, if you have as seller or as estate agent would like to have an advance on the purchase price or the commission, we can also, once again, if all the requirements have been met, pay you an advance from such a bridging finance loan. Right, what does the purchaser have to do in respect of the municipal account after the property is registered in his name? We will send you a letter confirming the transfer and also deeds of a search that will reflect you as the new owner. You need to take these two documents together with your identity document to the municipality to open a new account. They will then, of course, also require you to pay a deposit. What does the seller have to do in respect of the municipal account after the registration of the property in the purchaser's name? Once again, we will send you as a seller also a letter confirming the transfer and also the deeds of a search, and then you need to take those two documents together with proof of your banking details to the municipality to close the account. The municipality will then pay the credit to you. Unfortunately, however, that often takes a couple of months or even a year or longer with some municipalities before you will indeed get that credit. When can I as purchaser take occupation of the property? That depends on what your contract of sale stipulates. Sometimes there will be a certain date indicated, for example the 1st of June, then that will of course be the occupation date. Sometimes the contract will stipulate that the occupation date will be the registration date. In such a case, obviously the date is then uncertain. We will, however, keep you posted on the registration process and give you an indication as soon as possible of the expected registration date and therefore, of course, also the expected occupation date. Right, so I hope that gives you some idea of what the transfer registration process entails.